Perfect. Okay, so we'll kick off. So today we'll be covering making of advanced personal plans. My name is Solomon Bahani. I'm a solicitor with the General Legal Service within Darwin Community Legal Service. Session content today is we'll cover off substitute decision making and decision making capacity, which are really the two core concepts of an advanced personal plan. We'll also look at what an advanced personal plan is compared to other tools for substituted decision making. So things like a power of attorney or an adult guardianship order, and explaining those differences. We'll then just do a quick run through of the steps in making an advanced personal plan. I have a copy of the template form ready as well, so we can just have a look through piece by piece. And then we'll look at situations where advanced personal plans can go wrong, and what the process normally is in those situations. So we'll normally be going to a tribunal that would then have to determine what happens in the situation. So just a basic introduction to advanced personal planning. So personal planning is quite different to estate planning, and you may have heard of the term a living will to refer to an advanced personal plan, because that essentially that's what it is. So the estate planning is your will, and maybe if you have a superannuation account, the death benefit nomination form, that sort of thing. So it's really preparing for your passing, whilst the advanced personal plan is preparing for decision-making arrangements for yourself in the event that you can no longer make those decisions. So I'll just move this out of the way. There we go. Yep, so an advanced personal plan is the process, or advanced personal planning is the process of making arrangements for the management of your future health, financial, and personal choices, should you be unable to make those decisions yourself. Again, it differs from estate planning, which covers arrangements in the event of your passing. And in the simplest form, it generally involves appointing decision makers that will make those personal and or financial decisions for you when your capacity to make those decisions is impaired. Now, those arrangements will either be outlined in an advanced personal plan, or if you have made an enduring power of attorney before, I believe, 2013 or earlier, they would be outlined in your enduring power of attorney. Just note that enduring power of attorneys, which essentially are the same as an advanced personal plan, can no longer be made in the Northern Territory. So if you don't have an enduring power of attorney in place, and you don't need, if you don't have an enduring power of attorney in place, you don't need to worry about it. We just focus on the advanced personal plans. So advanced personal plans are governed under the Advanced Personal Planning Act in the Northern Territory, and the concept or the instrument under that act is called an advanced personal plan. Now, this is just for information, what is available in other jurisdictions, just so people can see that really it's just a name. It's just marketing by the government, essentially. They've just slapped a new name on an existing concept, and repackaged it through new legislation. But essentially, if you were living in the ACT, for example, it'd still be an enduring power of attorney. And for your health treatments, you could have a separate health direction. In other places, they could have stuff like an advanced care directive and an anticipatory direction. So there are different terms used in different jurisdictions, but they're all essentially for the same purposes. So the key concept in advanced personal planning. Yeah, Vicky, go ahead. Do you have a question, Vicky? Is the speakers on?
Yeah, try going onto the top bit. So look at the top, see if she's written a note in the top bit. Chat.
No, we will just continue. So the key concept for an advanced personal plan is decision-making capacity. So decision-making capacity is essentially judged by an adult's ability to understand and retain information about either a personal or financial matter, to weigh that information up in order to make a decision about the matter, and then to communicate that decision in some way. So it's not really a concrete criteria. So what could potentially fall within decision-making capacity or not fall within it is really on a case-by-case basis. For example, I've had instances where a client can understand and retain information about a matter. They can weigh and consider that information to make a decision. But for example, I've had family members say that they can't communicate it. And then I say, well, how have they been communicating with you? And they say, yes, they have. They can communicate through us. We have a non-verbal way of doing it. And then I explain to them, well, they have decision-making capacity because they're communicating it in some way. It may not be verbal communication. It may not be a way that can be understood by someone outside of that family group, but it is still a form of communication. And therefore, there could be an argument made that capacity is still there. Also, another key thing to think about is that it's related to a specific matter. So someone may have decision-making capacity for personal matters, but they may not have it for financial matters or vice versa. It's not you have been found to have impaired decision-making capacity, so therefore you can't make any decisions from this point onwards. It's specific. It needs to be specific to that matter.
Yeah.
Yeah. Was there a question?
No, because I'm still not Maddie. Yeah. Yeah, Maddie still no, okay, but I'll follow up again now. They are the thingy.
Oh, sorry, we're just turning the volume up. Could you just please repeat the question?
Yes, FCM will be the accrual back in August. Next week I should receive the bill maybe Wednesday. Oh yeah. Okay then. Bye.
Oh, sorry. Now, the Act also states that an adult is presumed to have decision-making capacity for a matter until the contrary is shown. So normally there needs to be evidence that the decision-making capacity is impaired before a decision-maker can start exercising that authority. And this is a very important requirement. And what you'll see is sometimes where a decision-maker is unsure, a safe thing that they could do is apply to the NTCAT, the tribunal, to get a declaration that the person may have impaired decision-making capacity for a matter. So then that way it's actually been through all the checks. So the evidence of the impaired capacity has been provided and an order from the tribunal or declaration has been made. So it sort of gives that exercise of authority an air of validity in the event of doubt. Now, an adult also, their decision-making capacity for a matter is impaired if any of those issues, if they can't do any of those things. So whether it's they can't understand or retain the information, they can't weigh that information up, or they can't communicate the decision in some way. They need to be able to do all three things to be deemed to have capacity for the matter. So we'll go on to the next concept of substitute decision making. So in the easiest sense or simplest form, it just means making decisions on behalf of someone else who can't make the decision for themselves. So you're sort of stepping into their shoes and making those decisions for them. Sometimes I have clients that will come to me and say, look, I can't do this. I can't, I guess, provide care to the person or provide the assistance that they need. And you sort of just need to explain to them, look, it's making decisions. It's not necessarily the direct provision of care. It's making those decisions of who's going to provide the care, how's it going to be arranged. It's that sort of thing. It's less intensive, but it still has an enormous amount of responsibility involved as well. But I do feel like people need to really understand what they're getting into before they do it, and not make a decision based on a misapprehension as to what the decision making entails or what the role entails. Now, there's been quite a development in the concept of substitute decision making. So in the earliest of times, substitute decision making was generally exercised by the family for persons with disabilities. And it was usually in instances to preserve their property for the benefit of the family. It wasn't so much about promoting the interests of the individual themselves. Later times, probably up to the 1970s, 1980s, there was really a theme of institutionalization. So people that had impaired decision-making capacity or were suffering from disability were essentially locked away and segregated from society. And in those cases, again, the substitute decision-making wasn't a thing that was really talked about, because it was just assumed that the institution would be making those decisions for the individual. As there was later declines in those institutions, and probably for good reason. But one of the issues was that a lot of these people had interests that should be or needed to be protected, but they weren't necessarily in a position where they could do that, because for example, if you have impaired decision-making capacity, it can be quite difficult because you can't really instruct legal help if you have a claim. Some people may not act on your directions, so there were problems. So Australian jurisdictions responded by implementing schemes such as guardianship, advanced personal plans. Really, those are the two main ones. I think they can make mental health orders as well. Child protection orders could be another example, but in relation to children. So that people could basically make those legally effective choices. And there is a Supreme Court case that provides quite good commentary on the development of this area of the law. And that's, I've just listed up there, Northern Territory of Australia, NDH. But that was in relation to adult guardianship, specifically the facts of the case. So substitute decision making is reflected in Section 8 of the Act. So it basically just states an adult who has planning capacity may, by making an advanced personal plan, do one or more of the following. So one is make consent decisions about future health care action for the adult. Now this is called an advanced consent decision. Now this is a healthcare decision that you make whilst you have planning capacity, and it is legally binding. So it will mean the decision makers need to follow it unless there's certain circumstances in which they shouldn't. And healthcare professionals or people providing care services to the adult have to follow it. It's legally binding unless there's usually an order of the tribunal not to do so. Now, the advanced personal plan can also set out the adult's views, wishes, and beliefs as the basis on which she wants anyone to act if they make decisions for him or her. Now, these are called advanced care statements. They are not binding like an advanced consent decision, but your substitute decision maker should still be considering it whenever they make a decision under an advanced personal plan, because they essentially need to make a decision that they have reasonable grounds for believing that you would have made in those circumstances, and that overrules any sort of concept of best interests. Usually they have to, paramount is the consideration of what would have the adult done or decided if they could decide for themselves. The final thing that can be in the advanced personal plan is that it can appoint the decision makers to make those decisions in the event of impaired decision-making capacity. And again, those decisions can relate to healthcare, finances, property, accommodation where you live, the relationships that you have. It can really be quite far-ranging, but the simplest way of understanding it is essentially personal matters and financial matters. Now section 20, so in the exercise of substitute decision making, your decision maker has authority to do anything in relation to that matter that you could lawfully do if you had full capacity. However, it is limited to situations where your decision-making capacity for that matter is impaired. So not just that it's impaired in general, it needs to be specifically for that matter. So an example could be if your decision-making capacity for financial matters was impaired, but your decision-making capacity for personal matters was otherwise fine. Decision maker they do not have authority to make decisions for your personal matters in that instance. You have that authority. It's your decision to make, and your decision could even be that you want them to make the decision, but it's still you exercising that authority, not them. And the authority is also subject to the Act and the terms of the advanced personal plan by which they're appointed. So you can put restrictions in the advanced personal plan, things you don't want them to do or decide. There are other things that they can't decide. So things like they can't, I guess, plead for you in a criminal case in the event that your decision-making capacity was impaired. I believe they can't vote on your behalf in elections. They can't do stuff like that. Now, in exercising their authority, they have to comply with a set of requirements. So one is the decision-making principles. We'll go through that a bit later. Again, complying with any restrictions in the advanced personal plan, complying with orders of the tribunal, complying with the Act. They need to cooperate with any other agents that you may have or any other decision makers. And they have to act honestly with care, skill, and diligence. Now, the final point is just sometimes, so decision makers can be appointed either jointly or severally, or jointly and severally, which is it's really based on a case-by-case basis how that applies. But in the simplest terms, joint appointments mean that the decision makers have to make a decision unanimously, so they both have to agree to it, or if there's more than two, they all have to agree to it. Severally means just one of them could make the decision and they don't need to check with the others. I'd say that the competing interests there are that there's flexibility and you could possibly, their decisions could be made more quickly if it was a several, if they were appointed severally, because they don't need to get everyone to agree. But the risk there is that it doesn't have those checks and balances because they don't need the other decision makers to sign off on it. So really what you're looking at is the speed of getting decisions done versus, I guess, the ethical nature of the decision or the prudence. Now, if joint decision makers can't reach a unanimous decision, what they do is they need to apply to the Northern Territory Civil and Administrative Tribunal. They'll each plead their case, and the tribunal will make the decision in the end as to what is the correct decision.
Solomon, with the finance side, we've had situations where a bank has not accepted an APP. What would the person have to do? Go by the bank rules, or is it something they have to do in law?
So that's actually a very good question. With banks, we need to remember when the decision maker can exercise that authority. And the key thing is that the capacity to make the decisions for that matter, so financial matters, needs to be impaired. Now, I could go and give the bank an advanced personal plan that's appointing me as decision maker.
Yeah.
They'll be like, they'll basically say, cool, noted, but there's no evidence that you actually have authority right now. So normally, if you were to do that, you shouldn't just be giving the APP. You should also be giving the evidence of impaired decision-making capacity as well. That would normally be a medical report from a doctor stating that this person's capacity is impaired and the advanced personal plan is now effective with this person as decision maker. Because without that, the bank has no evidence that the person has impaired decision-making capacity. And I could see it from the bank's perspective. I would certainly not act on just an APP alone, because all it says is if X has impaired capacity, Y makes the decision, but it doesn't necessarily say that X has impaired decision-making capacity. So if there are issues with the bank, normally that's the extra document that's needed. There needs to be some form of evidence that the person currently has authority to make those decisions. Now we'll just move on to personal and financial matters. So section 16 essentially states that the adult can make appoint the decision maker for care or welfare, including healthcare, such as personal matters, or property and financial affairs, which is your financial matters. If an adult does not identify the matters within the advanced personal plan, the decision maker is appointed for all matters. It's just assumed. Now, there's a non-exhaustive list of examples for matters in the Act. Now, this means that it's not limited to these items. It's just, this list just gives an indication of the stuff it covers, but it can expand beyond this list. But as you can see there, there's things like accommodation, your day-to-day living, including your diet and dress. So what you wear even, they could have decision-making authority over that. Healthcare, provision of services, that could include stuff like NDIS or my aged care as well. Relationships with other people, employment, education and training, banking, management of assets, insurance, legal matters. So it's quite broad. It really covers, it's aimed to put you in a position where someone can make decisions really in almost all scenarios if possible.
Yeah.
So as I said, you can appoint the decision maker to act at all times or only in stated circumstances or at all times except in stated circumstances. So one thing could be only in stated circumstances could be, for example, in the event that I am in hospital and need medical treatment, I'm not in a position to make the decision myself, but it doesn't extend beyond that. And then at all times except in stated circumstances, the most common example would probably be this person is my decision maker, except for when they're not in the Northern Territory, in which case it ceases until they come back. So you can appoint one decision maker or two or more decision makers for a matter, and you can separate them by matters. There's many different ways you can appoint them. Again, you can appoint jointly, so unanimous decision making, severally, so they can each just make the decisions, or jointly and severally. That could be an instance, for example, where you have two decision makers jointly appointed, but if one of them leaves the Northern Territory, it's several appointments until they return. So it's sort of like that sort of arrangement. And then if an advanced personal plan does not appoint a decision maker for a matter, you just have to note that there could be some uncertainty there, because in the event of impaired decision-making capacity, that deficiency may have to be addressed through another legal avenue. So it can be something like an adult guardianship order, because there's no answer in that situation. So can you just please use the wait.
No, the one I haven't got the invoice for July yet. Oh,
Just
You have to go to
if it come in here, should be come on my
get that
invoice.
sorted.
No, we
but-
pay for it, nothing.
Well, then how come there's no cost? If there's no cost.
No, the invoice.
Okay, move on to the next slide. And just be very quick, but I just think it'd be useful to cover the differences between substitute decision making and supported decision making. Supported decision making is a policy position that I personally believe should be adopted and changed to. Some limits with substitute decision making are that, again, you're dealing with a vulnerable person. There's a situation where they're most likely not going to regain capacity. And something like substitute decision making could essentially, in some instances, it could enable things like elder abuse. So you've got a situation where someone is making decisions for that person. And sometimes it can be quite hard to ensure that there's accountability of those decisions being made, or that they're doing it in the right way. Essentially, it's subordinating the rights of the individual, because it's deemed to be necessary in circumstances. Personally, I think supported decision making is a way forward. So this would be a situation where it's, the way I picture it is something like the decision maker rather than just making the decisions for the individual, maybe they just create some clear limits of what sort of decisions can be made. So it could be maybe generating 5 or 6 reasonable options and then just presenting them to the individual and allowing the individual to make their own decision as to what they want. And then the decision maker essentially just goes along with that. So I feel like that way the individual has their wishes heard and they actually still have that autonomy over how they choose to run their affairs. And there's nothing stopping a substitute decision maker from doing that as well. That can be the approach. And it is one of the requirements is that they do consult the individual or the adult to ascertain what their wishes are. But again, it's quite difficult to know whether or not an individual decision maker has actually done that. So I believe that substitute supported decision making is certainly the way forward. It's just about how that looks will be the relevant consideration. So we'll just go on to a case study. So we have Zara. Zara has an advanced personal plan appointing 3 of her children, Alice, Barry, and Clarence. They're jointly appointed for financial matters. It's no one appointed for personal, except if outside the Northern Territory, in which case the interstate decision maker will not have decision-making authority until they return. Clarence resides interstate. Zara has another child, Denise, who also resides interstate. Zara resides with Alice and her family, and Alice covers living expenses and Zara receives income from the age pension. So Zara is getting income from the age pension, but it's essentially spending money. All the living expenses are covered by her daughter. So Zara recently received a lump sum compensation payment from the National Redress Scheme. Zara has concerns regarding Barry's appointment as a decision maker for financial matters because he is a problem gambler. And this is a fact that she was not aware of when she made the advanced personal plan. Zara trusts Denise, but she's concerned because Denise works remotely and interstate, so it may cause issues in exercising that authority. Zara also, she likes having multiple decision makers because it ensures that there are checks and balances in the decision making. Remember that something like the best interests of an individual or what is in the best interest of an individual will differ from person to person. Just what one person thinks is in someone's best interest may be the complete opposite of what someone else thinks is in their best interest. So that's why the checks and balances are there. Zara has recently been diagnosed with early onset dementia, and there is medical evidence indicating her capacity to make financial decisions is impaired. So what's important there is that it is really only the financial decisions. We'll cover this concept later, but she has the capacity to make other advanced personal plans at this stage, and she has capacity to make her own decisions regarding personal matters. But essentially the others, right now, Alice, Barry, and Clarence have authority to make those financial decisions. I'll just leave it at that for now. We'll be coming back to this case study quite a bit. So the next item, part 2, is just, I'm going to go over the differences between an advanced personal plan, a power of attorney, and an adult guardianship order. Up there I've got photos of the power of attorney form, the advanced personal plan form, and I've got a photo from the Free Britney campaign. Now, Britney Spears, the pop star, was placed under what's called a conservatorship for quite a long time as well, which is an American version of an adult guardianship order. So essentially her father, I believe, was in charge of making her personal and financial decisions for quite a long time. And there was quite a big campaign to eventually get that revoked. So really, no one's beyond an adult guardianship order. It can essentially, anyone can really be subjected to it. It's that decision-making capacity criteria that's relevant, and that can affect everyone essentially equally. Everyone could essentially, at one stage or another in life, have impaired decision-making capacity. So the first one that we just cover is a power of attorney. So that's created under the Power of Attorneys Act. by the donor. So you have two people in power of attorney, the donor and the donee. The donor is the person who makes it, the donee is the one that will be the decision maker. It empowers the donee to act on their behalf under the law. So it's like signing documents, accessing bank accounts, paying bills. It's essentially split into a general and enduring power of attorney. General power of attorney is the only one that can now be made in the NT. To be created, the donor has to have legal capacity at the time, and it is revoked in a number of circumstances, one of which is when the donor's capacity becomes impaired. So you make it when you have capacity, it's revoked when your capacity is impaired. So they'll only have that authority whilst you still have your capacity. And you can also revoke it at any time that you have capacity as well before that. Again, there used to be an enduring power of attorney, which remained even after capacity was impaired, but they cannot be created after the 17th of March 2014. So advanced personal plans are now the tool that you will use. However, if you made it before then, it should still remain valid. If you have one, I'd recommend just reviewing it and make sure that it still meets your current needs. And if not, maybe it's a situation where you might have to consider revoking it and setting up an advanced personal plan. Now, an adult guardianship order is similar to an advanced personal plan. It's where the best way to explain it is an advanced personal plan is proactive. You make it, or it is made whilst you have capacity, and the authority is then granted or given to the decision makers when capacity is impaired. An adult guardianship order, on the other hand, is reactive. So it's where someone's decision-making capacity for a matter has become impaired, but there's no APP, so there's no advanced personal plan. So there's no real arrangement as to what happens. So it's sort of a comparison could be passing away intestate. So about what happens in that situation. Well, it means a third party needs to decide what happens. And in this case, it's the Northern Territory Civil and Administrative Tribunal. So someone has to apply for an adult guardianship order over the individual, and the tribunal will make a decision over who's appointed guardian and what powers they have. And sometimes guardianship isn't necessarily a bad thing. An example is that I have a lot of clients who they get admitted to hospital. The social worker at the hospital are trying to do the right thing by making them an advanced personal plan, so helping them set one up. And a lot of the time the client says to me, I don't even remember making this document. So again, I'd be questioning whether they actually have planning capacity when that happened. But you read the advanced personal plan that they made, and it will be appointing the public guardian and the public trustee. And my thoughts are, what's the point of that? Because it'd be under a guardianship order anyway. If they had impaired decision-making capacity, they didn't have an advanced personal plan, and there was no one else available, the public guardian and the public trustee would be appointed anyway. So what's the point of making that advanced personal plan? Because it actually causes more harm. Because what if they do have a family member that is available to do that role, and they want the family member to do it, but now they have impaired decision-making capacity, and they're now locked into an APP that's appointing someone that they probably don't want to make those decisions. And then there'll have to be a whole mess of going to the tribunal, most likely needing evidence that they didn't mean or intend to make it, or may not have had capacity when they made it, and it will cause problems. So if an APP appoints the public trustee and the public guardian, the only benefit I could really see from that would be if someone was going to be appointed to them, have them appointed anyway in a guardianship order, but they wanted to limit the sort of decisions that they could make. But outside of that situation, I can't really see any benefit of having an APP that appoints those two public bodies. But yeah, that's one of the issues of when I guess some people are trying to do the right thing, but they may not understand the potential consequences of what they're doing. So I'd be very hesitant about APPs that are made while someone's admitted to hospital. This is just a chart that I've made to sort of explain or I know that some people will be visual learners. It's essentially just showing a spectrum, and it's got decision-making capacity on one end and impaired decision-making capacity on the other. Except with the exclusion of the power of attorney, which has legal capacity and legal incapacity, because it's a different test. Now, as you can see with the adult guardianship order, decision-making capacity, there's nothing. Once it gets to impaired decision-making capacity, that's when the tribunal can make the order. And that's when the guardian has the authority to make the decisions once that order is made. With the advanced personal plan, we have two standards here. So we have decision-making capacity on the left-hand side. The advanced personal plan at that stage can be created or revoked. Now there's a lesser standard called planning capacity. So planning capacity is basically just the ability to understand the advanced personal plan that you're creating and to not be under an adult guardianship order. So it's a lower standard than decision-making capacity. At the stage of planning capacity, an advanced personal plan can also be created or revoked. And then the authority to make the decisions is on the right-hand side. So it's when the decision-making capacity is impaired. Now that's a very important concept, and I will cover it soon, planning capacity, because there can be situations, and I've had matters where clients have impaired decision-making capacity for financial matters and most personal matters, but we get clear evidence from the doctor, who will be a specialist, saying that they still have planning capacity. So it means that if they don't like the advanced personal plan that they have, they still have an opportunity to change it before the planning capacity is later impaired as well, in which case they wouldn't at that stage. And then just finally, power of attorney, it can be created or revoked when there's legal capacity, and it's revoked, and the decision-making authority is exercisable when there's legal capacity, and it's revoked once there's legal incapacity. So we'll just go back to Zara. So in light of Zara's diagnosis, Clarence is returning from interstate to care for his mother. Alice travels interstate to help Clarence with his relocation to the Northern Territory. So does anyone, could they pick up what the issue could be here? So essentially it's the joint and several. So
All interstate.
All interstate except one of them. So, I'm sorry, we've got a question. Hospital social worker here, sorry, our mic's not working. We would only put down public guardian, public trustee if client has directed us to do so. This is after multiple discussions where client has told us to do. They do not have family or they would like to nominate, but are keen to document their decisions in some way they can no longer do for themselves. This then informs the public guardian, public trustee for when the document becomes enacted. It's protective and proactive for the client in future when they themselves have been unable to nominate themselves. And that's good to hear that those checks are in place. But I would recommend that if it would also be helpful to just give the client the option to seek legal advice as well, and just so they can make that decision as to whether or not they want to consult a lawyer on what their other options could potentially be in this situation, and to have it explained to them what sort of role the public guardian or public trustee play and what alternative options they could exercise instead. But it is good that that process is in place. Yeah. Okay, due to concerns regarding Barry's problem gambling, Zara creates a new advanced personal plan appointing Alice and Clarence as joint decision makers for all matters in all circumstances. Zara, Alice and Clarence neither inform nor consult Barry regarding the new plan. In preparing the new advanced personal plan, Zara also receives a medical report from her treating geriatrician certifying her planning capacity. That's really important. Again, I would recommend if you make an advanced personal plan, you should always first get that letter. Get evidence from a documentary evidence from a medical practitioner that certifies that you have planning capacity at the time, because it could be the difference if someone later challenges the plan. It could potentially help defend it. Barry disagrees with this decision and suspects Alice and Clarence intend to exploit Zara. Barry then uses the former advanced personal plan to deposit Zara's entire compensation amount into a 5-year term deposit. Barry also locks Zara's bank account, which receives her social security payments. Barry will not confirm the nominated account receiving the monthly interest payments from the term deposit to either Alice or Clarence. Alice and Clarence will not allow Zara to talk to Barry out of fear he may coerce her into creating a new advanced personal plan. Barry also provided evidence of impaired decision-making capacity for financial matters to the bank, and the bank is now unwilling to speak to anyone until the matter is resolved. Zara feels she has caused unnecessary conflict within the entire family. Zara is considering revoking the new advanced personal plan, but does not know how decisions for her affairs will be made for her financial matters and future personal matters. So we just go by, do this step by step. So it seems that under the old plan, Clarence and Alice are both now interstate, so Barry's now the only decision maker. And under that, again, it's different perspectives of what's going on, but Barry's understanding now is that he can exercise that authority exclusively and he's put her compensation money into a term deposit to lock it away. Barry's intention may be good, that he wants to preserve it for her. We don't know the reasons why he's not telling them where the interest payments are. Remember that he might be of the view that the other two may be trying to exploit his mother. Alternatively, they may be of the view that Barry is exploiting Zara as well. Now, the thing is that unbeknownst to Barry is that Zara has made a new APP, so technically he isn't the decision maker when he does this. He's acted outside of his authority. And again, an easy way of resolving that is that you should always make your wishes clear to your family. So there should always be open communication. And that's what this case study really is trying to demonstrate, is when communication breaks down, the issues that it can cause. There's no point hiding the advanced personal plan from family members unless you have a genuine reason to do so, because it could actually cause more problems down the line. So essentially, Zara now doesn't have access to any of her money. And this could be quite bad if she wasn't already living with Alice and having those living expenses taken care of. That's really what's been quite a good scenario here. Now, Clarence and Alice won't let Zara talk to Barry out of fear that he may coerce her. Now, that could also be a bit troubling too, because her capacity for personal matters is fine. So technically, Zara should be allowed to talk to Barry if she really wants to. So there could be two ways of looking at that too. They think they're protecting her from elder abuse, but it could also be perceived by Barry that they are engaging in elder abuse. And if we look at it from the individual's view, it really should be Zara's decision at the end of the day, because there's nothing to indicate that there is impaired decision-making capacity for that personal matter. So
Can I just ask, you say that all family members should be included, but what if you're estranged from one of your family members?
So you don't have to share it if you're estranged from them.
Yeah.
But it could just be something as simple as just making your wishes known, but really it's up to the individual what they wish to do in that scenario. You don't need to tell them if you don't want to, but if you think it would help to just make it clear.
If it's one of your children, no. Because I've got two sons and one we know where he is and everything, but we don't communicate. It's his choice.
Yeah.
So can he step in?
So if he's not named in the advanced personal plan, it would be quite difficult for that individual to step in.
Yeah.
If it was adult guardianship,
Yeah.
there's no limit on who could actually apply for that.
Okay.
Yeah. So if that's a risk that if that was a risk that someone was concerned about,
Yeah.
I'd say that they should seek legal advice.
Yeah.
That. Yeah. And the good thing is it's as simple as just going upstairs.
Yeah. Yeah. Thank you.
We just had a technical error with the slides, just bringing it back up now. There we go, perfect. There we go. Oh yeah, this one has a graphic. So the next thing is just making an advanced personal plan. So to create your plan, you fill in the advanced personal plan form. It's available on the website, and I'll bring it up very shortly. The form has specific instructions that you will need to follow, and it also needs to be witnessed by an authorised witness. So I'll cover that too. To make, amend, or revoke an advanced personal plan, the person just needs to be at least 18 years of age. They need to have planning capacity, so decision-making capacity for making an advanced personal plan, and to not have an adult guardian. Sorry, I've just got chat. So can NT people nominate interstate family members to act, or do they need? No, so you can nominate anyone, that's my understanding. They don't necessarily need to be in the NT, but you need to provide their contact details so that if they are needed to make a decision, it's clear who can be contacted or where to contact them. So I'm just going to bring up the form and we'll have a quick run through. Oh, that's no good. Yeah, okay. Don't have to share screen again. New share, yeah, there we go. The form was open, wasn't it? Yeah, here, so this one. And then I go to this. Here's the form. Can everyone see the form? Yeah. So this is the template form. It's gazetted, so the government makes it, publishes it. Yeah. So we just have the explanatory notes, just read through this, very important because it explains each section of the advanced personal plan. You need to complete all the sections for it to be valid. There are some exceptions to that, so read that carefully. So you put your personal details here. Again, it's directed to your family, friends, and healthcare providers. Again, what this is about is making your wishes clear. So you got your name, your address, your state, postcode, place of birth or date of birth, sorry. Just stating that it's all complying with the requirements in the Act. Now we go to the advanced care statement. So again, is this bit legally binding or not? Does anyone want to have a go? Okay, well, yeah, so this is just stating what your views, wishes, and beliefs are about how you would like the decision makers to make decisions or health professionals to make decisions. So it's things like what gives your life meaning, what do you value most? So things independence, being on country, being able to work. If nearing your death, what are your goals or priorities? What is most important to you? So this is just really about making your wishes known. And again, I'd say that it's best to just be open and honest, include everything that you want to include in there. Don't feel embarrassed or that you have to hold anything back, because it's best that the decision maker actually knows these things so that you're helping them make the right decision for you. And you could even argue that this could actually be more of an example of supported rather than substituted decision making, or where there's sort of a balance between the two, because you're informing the decision that will later be made. There's stuff about consent to palliative care as well, and where you would like to pass away. Any other information about medical decisions, cultural and spiritual requests, and what's important to you after death. Now it's really important because you may think or assume that family members know this, but you would be surprised. You would be very surprised, because if you haven't told them, how will they actually know? That's really just the simplest way of framing it. The next section is on advanced consent decisions. Now, this is legally binding. So it's stuff like, your health practitioner has to cover it, comply with it, and your decision maker has to comply with it, unless there's a reason not to. And we'll get to that at a later stage. So it's if my heart stops and CPR is an option, do you want them to attempt the CPR? It's got unacceptable outcomes as well. So if, for example, they could do this, but these are things that could result from it, So you're sort of adding a qualification to your consent. So you're saying, look, I want CPR, but if I am not going to be in a state where I can actively move around as a result of that, and just go about my life as normal, go for a full recovery, I would not want the CPR in that instance. So it's just outlining what are unacceptable outcomes. There's also, you can request to be allowed to have a natural death, so no CPR. Specific medical treatments that you don't want, like feeding tube, blood transfusions. People sometimes have religious or spiritual beliefs that mean that they don't want to do these treatments, or they may just not be comfortable with it, full stop. And again, it's your right as a patient to decide what you consent and what you do not consent to. And again, yeah, any religious or ethical beliefs that may affect your treatment. If yes, describe how your beliefs may affect your treatment. So that could be quite helpful, and even just listing it generally could be helpful, because it could be a situation where you're obviously not going to be able to list how it affects every single medical treatment, but it could be something where there could be common knowledge that people of one certain faith do not like this certain treatment, and it could inform a decision not to do that. And if there's any ambiguity over what is to happen, there's always the tribunal to have a look at that. This is where you appoint the decision makers. So you can appoint them, you just need to put in their name, their address, and you just need to state what matters you want them, their contact details and what matters. So it can be all matters, it can be financial, it can be personal and health, or it can be limited, in which case you specify what you want them to make decisions about. Here is options for additional decision makers that you can appoint as well. Now, here's the important bit: if you have multiple decision makers, whether you want them appointed severally, so any one of them can make the decision, jointly, so it's unanimous, or other or specific circumstances. So there's that example again. If one decision maker is out the territory, I appoint the other. So this is where it's signed and witnessed. Now, with the authorised witness, I think it's always safest to get a medical practitioner to do it. I'm going to go through a list of who can do it, but it's always safer to get a medical practitioner, because one of the things they will be certifying is that the person understands the plan that they're signing. And the best person to do that would be a medical practitioner. And you could also then get the evidence of planning capacity whilst you're there as well. Now, if you can't sign, that's not an issue either, because you can direct someone to sign it in your presence. You just need to make sure that this is all done before the authorised witness. This is the seal if you get it registered. We'll cover that too. But we'll move back onto the PowerPoint slides. Can everyone see the slides? Yes, perfect. So back to just the formal requirements. So it must be in writing, either using the prescribed form or in writing in accordance with the requirements under the regulations. So this is important. You don't have to use the prescribed form, but I would always recommend you do, just to avoid the risk that it could be invalid. You need the prescribed form if you're giving someone power over financial matters. The prescribed form is required in that situation. Now, if there are no financial matters, you don't need to use the prescribed form, but if you do make your own, again, I would recommend that people not do this. You just need to make sure that it contains your full name, your date of birth, your residential address, your decision maker's full name, residential address, phone number, and email address, if any, for contact details. Sorry, keyboard's not working. Now, in the presence of the authorised witness, again, you must sign it, or you can direct someone to sign it in your presence. The authorised witness is certifying their reasonable belief that you are who you say you are, that you're at least 18 years of age, you appear to understand the nature and the effect of the plan, you appear to be making it voluntarily without coercion or undue influence, and the plan was signed by you or your representative in your presence or in their presence. Still not able to see the slide still on the form. Okay, I'm gonna just retry that. sorry about that. Where's the sharing? You are now screen sharing.
Try now sharing.
Yeah, I see it's the form still. Can you? So fixing that up. Is it? Yeah, there we go. See, authorized witnesses, so it's commissioners for oaths. So that can be a member of the Legislative Assembly, it's a member of the Commonwealth Senate who represents the NT, so that would be Jacinta Price or Malargiri McCarthy. It could be a member of the House of Representatives who represents the NT, so that'd be Luke Gosling or Mariam Scrimgeour. A justice of the peace, a police officer, a legal practitioner, a health practitioner, so it'd be a doctor, nurse, pharmacist, I believe even a chiropractor can fall under here. An accountant, a social worker, a chief executive officer of a local government council, Northern Territory School. Again, I think it's always safest to just get a doctor to witness it. Just because of that certification of planning capacity. Now you can register your advanced personal plan. Now it's optional, you don't have to, it doesn't affect the validity if you don't. You can register it with the public trustee. The good thing is that then there's an independent third-party record of it. You can also register it with the Land Titles Office, but you have to pay a fee to do that. Now, just note that Land Titles Office registration is optional, but if you don't register the plan with the Land Titles Office, any powers relating to or authority relating to dealings with land will not be valid. So it will not be effective unless the plan has actually been registered with them first. So back to Zara. So obviously there's been miscommunications and now no communication, and now the parties, the siblings, are all fighting amongst themselves. So Barry applies to the tribunal for 3 declarations. He wants a declaration that Zara has impaired decision-making capacity for all matters. He wants a declaration that the current advanced personal plan jointly appointing Alice and Clarence as decision makers is not valid. And he wants a declaration that the previous advanced personal plan jointly and severally appointing Alice, Barry and Clarence as decision makers is valid. Barry also wants an order from the NTCAT or the tribunal to amend the previous advanced personal plan to remove both Alice and Clarence as decision makers. So essentially what he wants is he wants Zara to essentially have all authority transferred to him. He wants the old advanced personal plan put in place, but he wants it changed so it's just him by himself making the decisions, and it will be decisions covering everything. Again, that's a bit difficult as well because I believe the previous advanced personal plan only covered financial matters anyway. Alice and Clarence also, they've been served with these notices, so they now apply to the tribunal to dismiss Barry's application. And they also want a declaration that the current advanced personal plan is valid and the previous one is not valid because they'd be claiming that the current one revokes the previous one. And Alice and Clarence also seek an order for, from the tribunal to Barry for the orderly transfer of decision-making authority. So they want the bank's stuff all transferred to them, so it's within their control. And the matters listed for directions hearing. So the tribunal will decide what needs to happen. Either they can make the decision on the day if they're comfortable, or if they're not comfortable, they'll set directions for the parties on how to proceed with this matter. So we'll now move on to APP disputes. This is the final part of this presentation. So the Northern Territory Civil and Administrative Tribunal is the NT's forum for many things. So the residential tenancies, so rental matter disputes, it covers small claims, but it also covers things like ensuring certain human rights are protected. And they do that through their adult guardianship and the advanced personal planning jurisdiction. NTCAT has jurisdiction to deal with matters under the Advanced Personal Planning Act. In exercising its jurisdiction in relation to a matter, the NTCAT has to act in accordance with the decision-making principles as if they were the decision maker. Now, the decision-making principles, I'm not sure why it hasn't come up on the slide. I might have skipped over it quite quickly. In the simplest way, it just governs the sorts of decisions that can be made, or how a decision maker exercises their authority. In the simplest way as possible, the simplest way of explaining it possible, it's just that a decision maker needs to basically inform themselves as to how they think the individual would have made that decision if they had the capacity to make the decision themselves. And once they've come to that conclusion, they then have to make the decision that way. Now, if they can't form a reasonable belief as to how the individual would make that decision, or they have, but the way that the decision would be unlawful, or they're unreasonable, or something that they clearly didn't intend, in that case, they have to make the decision in the best interest of the individual. So the paramount method is, how would the adult make the decision themselves if they had the capacity to do so? And if that's not applicable, you make the decision in what is in their best interest. This best interest can be a bit difficult. Both can actually be a bit difficult because different people may have different views regarding both. So the best way, the decision-making principles essentially say that to try and make sure it's as accurate as possible, there's really a strong obligation on the decision maker to consult. So consult with the individual themselves, so consult with the adult under the APP, consider what their previous wishes have been expressed in relation to a matter. If it's something where they've clearly said in the past that they don't want it, you shouldn't really be making that decision then, even if there is a bit of an ambiguity. Also consulting with other people that may know what the person may want, that's another thing that's generally expected. And if they can't make a decision at all, they may have to actually apply to the tribunal to get a decision. So the tribunal does the exact same thing. When they're considering a dispute in a matter, they're essentially following those decision-making principles as well. They're standing in the shoes of the decision maker. Generally, proceedings must be commenced by an application that's made by either the adult themselves or an interested person for the affected adult. So that could be a relative, or someone with a genuine concern for the individual. And proceedings are conducted in private and not open to the public. That's obviously for good reason, because these are very personal matters. Unless it appears to NTCAT or the tribunal or the justice will be best served by the proceedings being open. But that would be quite rare for something like that to happen. So NTCAT orders, they can make a number of orders on a party. So one is declarations, so just a statement of what should happen or what is correct or incorrect. Orders as to how a decision maker should be exercising their authority. So sometimes the decision maker could seek that, sometimes someone else may seek that. Orders to a former decision maker. So that could be an instance where the plan has changed and they're essentially trying to arrange the orderly transfer of authority from the old decision maker to the new one. It could also include transfer of documents and things like that, where the adult has since passed away. So from the APP, from the decision maker under the APP to the executor of the estate. They can also make orders to amend or revoke an advanced personal plan in certain instances. They can make orders to endorse the ceasing of a decision maker. So where a decision maker has resigned, for example, just for clarity to show that they no longer have authority. They can also make orders for urgent consent decisions. So normally that's applied for by medical practitioners, and it's normally where there isn't an advanced consent decision and they can't find a decision maker who is willing or able to make the decision. So what will happen is the medical practitioner will apply to the tribunal to try and get the medical decision. Usually the decision they need to either make the decision or decide to adjourn it if they don't believe it's urgent within 24 hours of the application. And they shouldn't be making decisions for treatments that could be exceeding 2 weeks in duration. So we'll just do a quick run through 2 of these items. So declarations, it's quite clear the tribunal can make declarations about things such as whether an adult has impaired capacity or decision-making capacity for a matter, whether an advanced personal plan is valid, whether a statement in an advanced personal plan about healthcare action is an advanced consent decision, so a legally binding decision, or an advanced care statement, so just an expression of what your wishes are. Or whether or not a decision maker has authority for a matter, for example. So there's quite a few things that they can do. And it also covers any other matter arising for determination under the Act as well. Now there's amendment or revocation of the advanced personal plan. Now this is usually in very extreme situations. And so we'll just cover that. So the elements of when they could amend an advanced personal plan is that there are grounds for amending the plan. The amendment is reasonably necessary to address those grounds. And if the adult had planning capacity, he or she would agree to the amendment. The NTCAT can amend the advanced personal plan so as to terminate the appointment of a person as a decision maker, but it's only when they're satisfied that doing so is the only practicable way to address the grounds for amendment. Because remember, you're sort of going against the wishes of the individual there. From when they made the plan. They can also revoke the plan if satisfied that there are grounds for amending the plan, and revoking the plan is the only practicable way to do it. And the adult would agree to the revocation if they had planning capacity. So the grounds, I have them written down, but just to quickly cover some examples of what they include. It can be situations where giving effect to a plan is for all practical purposes impossible. Where giving effect to a plan could be unlawful, where they believe that the adult was, in making the plan, the adult was not acting voluntarily or was adversely affected by dishonesty or undue influence by someone. It could be where a decision maker has failed to comply with the decision-making principles. That could be one example, or it could even be stuff like major changes in circumstance, or where agents can't actually get along, work together. So they're stepping in to say, look, the person's potentially going to suffer as a result of this, so this is really the only way we can do this here. So just to the case study, just to wrap it up. So before the directions hearing, Alice and Clarence received a call from Denise. Denise advised that she and Barry, at his own initiative, opened a new joint account for Zara to receive the monthly interest payments on her term deposit. Denise explained Barry, who is aware of his problem gambling, had arranged for her to be a joint account holder on a both to sign basis to ensure he does not make any unauthorized withdrawals. Barry had been clear that the account and associated term deposits are held on trust for Zara. That is a requirement if you are a decision maker for financial matters. All property has to be managed as trust property, so separate from your own. You cannot accept that person's money into your own bank account. It needs to be completely separate. You cannot commingle funds. Alice and Clarence advised Denise of the situation. Denise also speaks to Zara to confirm the situation. So Denise is doing the right thing here by actually calling the one person whose view actually matters at the end of the day and clarifying what's happening. Because again, and we do it in these situations where families are fighting, we just talk to the client because we don't know what's happening. The people that they're currently with could actually be the ones that are causing the problems for all we know. It's the only thing that matters is it's what the client says. Denise speaks to Barry, but he refuses to listen. Barry is concerned that Alice and Clarence have coerced Zara. The matter will proceed to the tribunal, so they can't resolve it themselves. So luckily, Zara, when she made that new advanced personal plan, she got a report from the geriatrician certifying that she had planning capacity. So that's strong evidence there that it was validly made. So the tribunals essentially said that the new plan is valid and the previous plan that appointed Barry, Alice and Clarence is now revoked. The tribunal was also dismissing Barry's application to amend the previous advanced personal plan, and there are many reasons for this. Firstly, it's because the advanced personal plan that he wants in place is revoked, so there would be no point. Also because Zara has planning capacity and because Barry has not provided any evidence of any grounds for amending the previous advanced personal plan. He has no evidence that the other siblings have actually done anything wrong. It's just mere suspicion and paranoia, and could have been resolved if you'd spoken to them. Now, the tribunal also refuses to make the declaration sought by Barry that Zara has impaired decision-making capacity for all matters, as no evidence has been provided to as to personal matters. It's only financial matters, and what you'll find sometimes is the tribunal is a bit hesitant to make the declaration because they don't really want to get into technicalities. It's only really where it's clear cut that they'll be in a position where they're comfortable making a declaration. The tribunal also orders that Barry facilitate the orderly transfer of decision-making authority. After the hearing, Barry explains the rationale for his actions and reconciles with Zara, Alice and Clarence. Barry promptly transfers the balance of the term deposit and interest payments to a trust account held by Alice and Clarence. Barry assists Alice and Clarence to unfreeze Zara's bank account. Alice and Clarence are comfortable with Zara having unrestricted access to her age pension, and assist Zara to arrange an international cruise that she has long desired with some of her compensation payment. Alice will accompany her on the cruise, but of course Alice will be self-funding her participation in the cruise. That's a good outcome. That's something that we don't see in a lot of cases. And I think it's very interesting because it shows the differences in what would be perceived to be in an adult's best interest. Now, in Zara's case, the unrestricted access to the age pension, it's probably the best thing for her because there's no risk. Zara should be allowed to enjoy her money. This is just my view as well. This may not be the view of someone else or a tribunal, but my view is Zara should be able to enjoy her money while she can. And there's no risk. If Zara spends the money on something that we may deem to be silly, just in our own personal opinion, there's no harm because Alice is there to provide for her living expenses. So there's no real issue. So why deprive her of that? What are you really protecting her from? If anything, you're actually causing more harm. And another thing that we can see is there are sometimes these arguments where one person's going, no, we have to lock the money away and keep it safe so that they can secure their future. And the other person saying, no, they should be allowed to enjoy it while they still can. Let them go on the international cruise, for example. And there's two ways of seeing everything. So the locking away of the term deposit, to one person, you may be preserving someone's financial independence and making sure that they preserve that amount. To another, they might say that's elder abuse. You're locking away the money so that they pass away and then you inherit it. There's two ways of looking at it. I'm sure both sides have the best interest of the individual at heart, but that's one of the flaws of the best interest test is it's subjective. And it's something that we can see quite often now with compensation payments because things like the redress scheme and the stolen generations compensation scheme, unfortunately, it's good that the compensation is being paid, but it's a bit too late. That's probably the issue. I'm just trying to point out. It's being paid to these people who have endured horrible things, usually when it's towards the end of their life, and they're really at risk of things like elder abuse, or there could be someone who thinks that they're doing the best thing for them by locking the money away so that they at least have security of getting those payments. But maybe it's a situation where they should be allowed to enjoy their life or the rest of their life while they still can. And it may be in their best interest that they be allowed to enjoy that money. So that's really what this case study is about. It's about there's different perceptions. And the best way of addressing it is really making those wishes known to your family members and just being open about it and not being afraid to express what your thoughts are because it's about you at the end of the day. So on that note, thank you all for your attendance. Are there any questions from anyone? I'm sorry, we're just getting the chat. Oh, thank you. Okay, well, we'll wrap it up here. Thank you all for attending.
Yeah, thank you. That was
Thank you.
interesting.
That's very good.
Yeah.
And now I'll work out how to end the recording.
Stop sharing.
Stop sharing, yeah.
And on the top.
So